straight ahead on Law and Crime Daily.
Ladies and gentlemen, I've been informed that you have a verdict.
A verdict is handed down for the convicted Daytona Beach serial killer, and a spotlight shone on the mental health issues of convicted church shooter Dylann Roof, while his legal team has filed a petition with SCOTUS. Plus,
this is not the outcome that we and so many had hoped and prayed for over the last year.
The adoptive parents of Orrin and Orson West now charged with their murders. But first,
we, the jury, find the defendant, Brett Hankison.
We are live in Louisville, Kentucky, just hours after a verdict is handed down in the trial of ex-officer Brett Hankison. Law and Crime Daily, covering court cases from coast to coast. Welcome everybody to Law and Crime Daily. I'm Imran Ansari, in for Brian Buckmeyer, who is in Kentucky covering the death of Breonna Taylor case. Here with me in New York is co-host Terry Austin. A verdict is handed down in the case of ex-Louisville officer Brett Hankison, charged in connection to the death of Breonna Taylor. Hankison was not charged in Taylor's death, but instead faced charges of wanton endangerment for firing shots into Taylor's apartment that went through the wall in the neighboring unit. Hankison was one of 3 officers involved in a no-knock drug raid performed on Taylor's apartment in March of 2020. Believing the officers were intruders, Taylor's boyfriend, Kenneth Walker, fired at them. The officers shot back, and Taylor was killed in that crossfire. Former officer John Mattingly was also shot. Officials say ex-officer Miles Cosgrove fired the deadly rounds that killed Taylor. On Thursday, defense attorney Stu Matthews presented the defense's closing arguments, saying Hankison acted to save the lives of fellow officers.
Brett Hankison did not know there was an apartment behind Breonna Taylor's that his bullets could go into, and I would submit that even if he had, he did what he thought he had to do in that instant. And that's what you have to be cognizant of, is this all happened in such a short span. Ladies and gentlemen, the bottom line is that through all this, the Commonwealth is trying to say that because Brett Hankison took the actions he took, he's a criminal and he deserves to be in prison. I submit that Brett Hankison's the farthest thing from that. You heard how he reacted to try to save his brother officers. You heard everything he did, police-related activities that he engaged in after the shooting was over.
Assistant Attorney General Barbara Whaley countered, saying enough evidence was presented to convict the former officer.
This case is about the actions of Brett Hankison when he shot into the side of that building in the opposite direction from those who were in the line of fire coming out of the apartment. The evidence that you've seen from the Commonwealth and the defendant's testimony is that he is guilty under this law of wanton endangerment of Cody, Chelsea, and 5-year-old Zayden, whose head was on the pillow right in the corner of that bedroom, closest to where the bullets were flying through. He is who this case is about.
Then after only 3 hours of deliberation, jurors reached a verdict.
We, the jury, find the defendant, Brett Hankison, not guilty of wanton endangerment in the first degree under instruction number 4, as that applies to Cody Etherton. As to Chelsea Napper, we, the jury, find the defendant, Brett Hankison, not guilty of wanton endangerment as to verdict form number 3, wanton endangerment, first degree, as to Zayden F. We, the jury, find the defendant, Brett Hankison, not guilty of wanton endangerment.
You heard it there, not guilty on all charges. Our own Brian Buckmeyer was inside the courtroom as that verdict was read. He joins us now live from Louisville, Kentucky. Brian?
Yeah, Imran, as you said, not guilty on all counts for wanton endangerment as it applies to all of the 3 alleged victims in this case. Now, during the reading of the verdict, you could hear a pin drop. You had the family of both Kenneth Walker as well as the family of Breonna Taylor in the room. No outbursts, no kind of screaming when it came down to that not guilty verdict. However, as the families walked out, you can see distress, some anger, and even some sorrow, especially in the faces of the Palmer family, that being Tamika Palmer, the mother of Breonna Taylor. Now, I got to speak with Brett Hankison's defense attorneys just minutes after the verdict, where they talked about this being the first day of the rest of Brett Hankison's life, and that he's looking forward to being not convicted of these charges and going on in his life.
Well, Brian, that's great reporting. And joining us today is co-host Terry Austin and also trial attorney Bernarda Villalona. Bernarda, I want to start with you with the basics. Do you think the jurors reached the correct verdict here?
So in regards to Brett Hankison and what he was charged with, I believe that the jury did reach the correct verdict in this case. And I called it from day one doing opening statements. I didn't believe that the prosecution would be able to prove beyond a reasonable doubt that Brett Hankison took an unsubstantial and consciously disregarded an unsubstantial, unjustifiable risk. Because when you think about it, he responded like anyone would respond. Shots were being fired and he returned shots in order to protect his fellow officers. Yes, it's the answer that we don't like, but it's the one, according to the facts that were presented and the prosecution having the burden of proof, it is the correct verdict. In the end, he wasn't charged for anything having to deal with Breonna Taylor. That issue lies with the Attorney General, Daniel Cameron, who decided not to bring those charges to the grand jury to decide.
Yeah. And Terry, does this verdict, does it fall back, do you think, on the prosecution's closing arguments? Where do you think that the prosecution fell short in not getting this conviction?
Actually, I agree with Bernarda. I think the prosecution fell short in the very beginning throughout this trial. She failed to tell a story. She mentioned during her closing that Hankison shot in revenge for shooting his fellow officer, but there was never any evidence about that at all. And frankly, the other police officers simply didn't support that theory. Hankison himself said he was defending his fellow officers. And by the way, they shot into neighboring apartments as well. So I think that all in all, she failed and she did not prove her case. And that's why we got the verdict we did.
Yeah, and Brian, you were in the courtroom for it all. How did the jurors react to those closing arguments we saw?
So the jurors were pretty stoic. I thought that they were listening. I agree with Bernarda and Terry. Up until closing arguments, I didn't really think the prosecution was carrying their burden. I thought they got a little bit closer to that in summation, mainly because of the organizational skills of the prosecutor and how the jury was being attentive. But I think it was far too late, and that's why we got the verdict we got, even though the defense's closing arguments was only 24 minutes, because per Stu Matthews' own words, the rulings prior to that closing arguments eviscerated his closing, but it seemed to be enough for the jury.
And the jury has spoken not guilty on all 3 counts. Thank you, Brian. Still ahead on the Law and Crime Daily, attorneys for convicted killer Dylann Roof case. A sad ending to the search for 2 little boys in California reported missing 14 months ago. The district attorney in Bakersfield, California says Orrin and Orson West are dead, but their bodies have not been found. Law and Crime's Anjanette Levy is here with more.
Imran, a grand jury has indicted Orrin and Orson West, adoptive parents, on charges of felony child abuse and second-degree murder. And sadly, the Kern County District Attorney says that those boys were actually killed 3 months before their parents reported them missing in December of 2020. Now, Orrin and Orson's were reported missing by those parents, Trezell and Jacqueline West. And police said the Wests initially told them the boys wandered away from their backyard in Cal City, California, and walked into the desert, quite possibly. Shortly thereafter, the Bakersfield Police Department became involved in the investigation. And the investigation spanned 14 months and included the execution of more than 40 search warrants. The district attorney said she can prove that the brothers are dead.
One of the questions that I'm sure you would like to know is, have the bodies of Orrin and Orson been found? And the answer to that is no. they have not been found. However, I would like to emphasize that the fact that law enforcement have not found their bodies does not preclude a murder prosecution. As a matter of fact, there have been many hundreds of what we call no-body homicides prosecuted across the United States successfully, and even no-body homicides have resulted in murder convictions in Kern County.
Now, because this case was indicted by a grand jury, many of the details about the investigation and the allegations are not being made public at this time, and the DA will not say why the Wests were charged with second-degree murder rather than first-degree murder. Jacqueline and Trezell West appeared in court in Bakersfield, California on Thursday. They were ordered held without bail and both pleaded not guilty. Imran?
Thank you, Anjanette. And now let's bring back Terry and Bernarda for more legal analysis. Terry, I'm going to start with you. If the bodies of the children have not been found, how do you think the authorities are going to be able to determine when these deaths occurred?
Well, one of the things the DA said is that it's a combination of this direct and circumstantial evidence that they have. They had 50 witnesses at this grand jury proceeding, and apparently they know enough to know that these two children are dead. So maybe they saw a witness who said that the boys were being carried out, or maybe there was a video that showed some packages being carried that looked like it could have been the bodies. They could even have audio recordings where one of them is admitting that there was some sort of fight with the children, and perhaps that has been taped and they can use that. So I think there is a lot of evidence pointing to the death, particularly because we know that they have a timing of it. And they don't want to show their cards right now. They want to keep all of that secret so they can use it when it comes time for the trial. And, you know, they could even have DNA evidence of blood, even if they don't have those bodies.
Yeah, Bernarda, I want to ask you, you're a former homicide prosecutor. What does it mean that the adoptive parents, Jacqueline and Trezell West, were indicted by a grand jury?
This is such a tragic case. Unfortunately, of course, what happened is that a grand jury determined that based on the evidence that was presented by the prosecutor, that there was sufficient evidence to, one, determine that these parents, these two individuals, were the ones that were responsible for the death of these two kids. But also there's probable cause to believe that they also were the ones who actually committed this homicide. So it's not only that they're dead, but that these parents were the ones who committed this homicide. This is not anything out of the ordinary. With a grand jury proceeding, you had 16 individuals at least that heard the testimony and made that determination. It's going to be a long while before we hear what exactly was presented because grand jury proceedings are sealed.
Yeah, and Anjanette, has Kern County prosecuted no-body cases in the past?
Yeah, Imran, it's actually pretty interesting. Cynthia Zimmer, during that press conference, said, as you heard, that there have been these no-body prosecutions across the country that have been successful. And she said, actually, in Kern County, they've had 2 in the recent past no-body homicides where a conviction was obtained on those cases. She said there could have been more in that county. She just doesn't recall them or wasn't around back then.
No matter what, it's a real tragedy. Thank you. Coming up on Law and Crime Daily, convicted killer Robert Hayes learns his sentence in a Florida courtroom. Plus, mental health issues take center stage in the case of convicted South Carolina church shooter Dylann Roof. What petition South Carolina church shooter Dylann Roof turned to the Supreme Court for guidance on mental health issues with a defendant. This all stems from Roof's 2017 death penalty sentencing, during which Roof fired his legal team, and in a petition, attorneys said Roof was, quote, under the delusion that he would be rescued from prison by white nationalists, but only, bizarrely, if he kept his mental impairments out of public record. Attorneys have now petitioned SCOTUS, asking who gets the final say. When a capital defendant and their attorneys disagree on whether to present evidence that they are mentally ill. In 2017, Roof became the first person in the United States to receive the death penalty for conviction of a federal hate crime. So far, all appeals to overturn that sentence have been rejected. In 2015, Roof opened fire on a Charleston, South Carolina church, killing 9 African-American people. All right, let's bring in Bernarda and Terry to break this down. Bernarda, I'll start with you. What factors do the Supreme Court have to take into account here? What sort of decision could we end up seeing?
So we're going to see a whole bunch of conflicting issues in this case because you are guaranteed under the Constitution the right to effective representation, legal representation. So if that is the case, the attorneys are acting in the best interest of the client in order to give them effective representation, especially if they believe a defense that they're going with can mitigate their exposure. And that is what is going on in this case. The question's going to be, and the court's going to have to decide, who should we believe? Who should actually make such a crucial decision? The person who doesn't have a law degree, the client, but who has so much to lose, or the person with a law degree and can apply that effective representation and see how it's going to affect the rest of the country, this decision.
Yeah, and Terry, Dylann Roof was found competent to stand trial. Do you think that was the correct decision?
Actually, I do think it was the correct decision here. He seems perfectly competent. That simply means that you're able to understand those proceedings and that you can take part in your defense. And clearly, he is taking part in his defense. It's very different from whether or not you can assert mental illness, meaning you didn't know the difference between right and wrong. Here, the competency means he understands these proceedings. One of the things I was thinking about is if he has so far stated he has no remorse for these killings, and he has said that, why not just plead not guilty? So it's interesting. He understands what's going on, and yet he still has pleaded not guilty. I don't understand why he doesn't plead guilty, rather.
Mm-hmm.
Yeah, we'll all be waiting to see how SCOTUS rules on this. Very interesting, and we'll bring it to you. When we come back, we head to Florida for the final chapter in the penalty phase for Robert Hayes. Welcome back to Law and Crime Daily. A convicted serial killer will spend the rest of...
I judge you guilty, sentence you to life imprisonment without the possibility of parole. In count 2, I adjudicate you guilty, sentence you to life imprisonment without the possibility of parole. And count 3, I adjudicate you guilty, impose a life in prison without the possibility of parole. Each sentence shall run consecutive to one another.
Last week, a jury convicted Hayes of killing 3. Hayes' DNA was linked to the 3 Daytona Beach murders. Throughout the trial, the state's case leaned on that DNA evidence. Meanwhile, the defense argued Hayes' DNA was found because he had sexual encounters with the women before they were killed. Hayes is also charged in that 4th murder in West Palm Beach. He will go to trial for that case at a later date. All right, let's bring in Bernarda and Terry. Bernarda, I'm going to start with you. Hayes avoided the death penalty here, but he's set to stand trial for a 4th murder. Could a second jury be as forgiving?
No, I don't think so. We're dealing with a different group of people, a different set of jurors, and those jurors will probably not be forgiven for his actions. The sad part about it is that I don't believe they will know about this conviction of these 3 women that he got convicted for killing. So we'll just have to wait and see.
Yeah, Terry, the judge decided that the life sentences should run consecutively. Why do you think he decided consecutive sentences instead of concurrent sentences?
Well, listen, Imran, the judge has the discretion to decide whether or not it's concurrent or whether it's consecutive. Obviously, concurrent meaning all at the same time, consecutive, one after the other. And what he's doing here is he's looking at these aggravating and mitigating factors to make that determination. And clearly, since he said consecutive, it means that he's thinking to himself, these aggravating factors were very serious. And there were 3 murders here. Bernarda's right. They probably won't hear that because of evidentiary rules, making it more prejudicial than probative. But we know here there were multiple murders, and that is one of the main aggravating factors. And the judge is probably also thinking about the fact that this was cold, calculated, and premeditated, what they call CCP. And he's thinking to himself, should I run this consecutive or concurrent? And he definitely decided this should be consecutive. When you think about it, at the end of the day, it's life without parole. Physically, it's not going to make a difference because he runs it consecutive or concurrent, it's a life sentence. So he's just sending a message.
Yeah, he will be behind bars, we know that. And thank you for joining us here at Law and Crime Daily. We will see you next time as we discuss justice in America.